I just thought we could start with trust. The ultimate trust is the Sedeke trust. That's our trust. It's a straw man. It's a birth certificate. Isn't that where it starts? So it kind of ends where it starts.
Circles back, yeah. Well, that's basically a secret trust, and every time they want you to hand over your name, you're handing over to a trustee your particulars about that estate, right? All the particulars on the source documents and the birth certificates and portfolio numbers and book entry numbers.
When I went bankrupt in 2018, that's when I learned about the straw man and the Sedeke trust, because I'm going through this financial turmoil, and then I realized that there's this secret trust that was created that I had no idea even existed.
Yeah, and if they want to wind up or charge that trust and for their own profit and gain, it's like a mini liquidation or a small bankruptcy. And so what they're doing is, because that trust is linked to you, the living, and you're beneficiary heir of that trust, you're the survivor heir, remaining heir. And so basically they come in as a trustee decent tort or a trustee with no authority, and they want to wind up that trust. So in a bankruptcy notice, it'll be titled "The Prosecution of Yourself." So the idea is to have you prosecute your brother or twin for a payout. And so that payout, of course, they're seeking, for the administration costs. And they're setting up as a corporate trustee, right? They set themselves up as a trustee in the public to administrate these debts, and they're establishing and creating new debts all the time. That's the rort, right? They're charging the estate all the time with these fabricated fees, fines, levies, charges, and costs. And so they need to create policies, right, and acts to accompany that, or to allow these charges. So they're just manufacturing charges against the estate.
Where does the Bankruptcy Act come into all of this? Because I noticed the Bankruptcy Act came in like the 30s, and then it got redone in the 60s. And my sneaking suspicion is the Bankruptcy Act has got nothing to do with the liquidations out in the public commerce space, but actually the liquidations in the private.
Well, that's why it went into trust, right? Because when they took the right for you to pay anything in the public, it had to go into trust. If it goes into administration, it also goes into trust, right? So if you can't pay for a debt, so when it went into trust, you could only discharge a debt, right? So if you can discharge a debt, a form of that is a promise to pay. So they started pushing the bills of exchange and subrogating security. So your security was the promise. So I promise to pay. And so they'll have these schemes, these government guarantees that, don't worry, all your debts are guaranteed. And so they're guaranteed by the scheme under trust law that there's a security there, or a bond or a pledge, whereas the government can always get paid. You just don't know the mechanism of that. It used to be, you could discharge by paying $20 or the debt with cash. But when they took gold away from the currency, it came off the gold standard, there was no real consideration, because there's no real value
So
to the dollar.
are we paying debt with debt? Like, how does that work?
No, we're discharging with a debt note. We're servicing the obligation to the extent where it's discharged into the future when gold comes back behind the currency. So it's a promise till then. So everything's built on promises, and that's the new security, is your promise into the future to pay at some time, and that under a scheme it's like a subrogation of security. So that's the security you give. And so now they send everybody out in the public to secure those securities or promises through contracts. That's the commerce. But when commerce is breaking down, as we just explained, trust law is going to prevail. Equity will prevail. And so basically that's why we always have discharge. And this is what those one way to define that is in trust law, when you have in the tax acts debt forgiveness, for natural love and affection, that comes under the relationship of a trust, right? When the trustee, as the creditor, has the right to discharge debts for the beneficiary. Usually, in this instance, beneficiary are the children. So, typically we're all minors in an estate. Our trust is holding us as, our trust perceives us as minors. So it's called a minor's estate or an infant's estate, right? And so as beneficiaries, we don't go around offering to pay. There's a trustee uh, for that job. So the trustee is usually the creditor, because if the trustee is paying, they would be the creditor. As uh, They would assume the liability as the creditor, and they will go and discharge or pay or add a security or make a promise, whatever they need to do, right? It's usually for the benefit of the child. So this is where the trustee has a lot of power, rights, and they can discharge an obligation for the natural love and affection they have for the beneficiary,
So in this trust,
right?
are we the trustee? Are we the beneficiary? Are we the executor? Like what is our role? Like this trust was created for was it created for our benefit? It was created on behalf of us, or what is our role in that?
Well, it appears that they treat us as a minor and they treat us as a child or infant when it suits them. So when we're traveling around the roads and we get into some grief or trouble as a child, they treat us as a child appropriately and say, oh, do you want to be on a good behavior bond? So on a good behavior bond, they're treating you as a beneficiary of some kind of relationship. So usually the governments will have a constitution to create an express trust where the people are the beneficiaries, and there's an implied trust, say like on code of conduct on the police website. They'll have a code of conduct. And if you read that, what they're doing is delivering a message or delivering protection or well-being care to the beneficiaries. It'll read like that. So that's the implied trust. We're always looking at legislation and policy thinking, oh, this is where they're creating, establishing. No, they're establishing through code of conduct or code of ethics and implied trust. So when they pulled you over, they'll ask, why, do you know why I pulled you over? And you can answer, well, because I'm a beneficiary of a trust. So when you invoke that trust, that law of equity, they can't hurt you, they can't injure you, they can't grab you from the car. They must provide a benefit. Beneficiaries only receive benefits. They don't receive bills to pay, because that should be sent to the trustee. So don't allow them to confuse you as one day a minor, child or beneficiary, and then the next day a trustee, somebody who's going to pay. Because typically you could just write back and say, look, I can't be the trustee and beneficiary of my own trust. There are rare circumstances where you can, but don't fall for their game where they're trying to, put you down as co-trustee. So, for example, in a court case, they'll come in as plaintiff beneficiary because they're asking the trustee of the trust to reimburse them for a cost of a service in the public. Whatever service they offer in the public is going to have a fee, a fine, or a penalty.
Mm-hmm.
And if you acknowledge the debt as a trustee, or you don't acknowledge the debt as a trustee, you become a delinquent trustee. And that's why they chase you down for the debt. In a court case, when they bring action against the trust, they bring it as a plaintiff beneficiary. So a plaintiff beneficiary is a plaintiff seeking remuneration, usually for a service in the public. So they're masking that it's a trust relationship, but they blow their cover when they start seeking payment. You can write in or you can respond by saying that as a beneficiary, you can't be compelled to talk about the trust as you signed an NDA, and specific terms of the trust are confidential and private. But they can reach out or write to the trustee or executor of that trust seeking further assistance, but it's not your job.
I'm still confused. Sorry to cut you off, but Wait, are we the trustee or are we the beneficiary? What one are we?
Well, they're trying to confuse us. That's the whole point. But if we're the beneficiary, right, and this is where we want to be. We want to be either the grantor or the beneficiary. As the beneficiary, one way to sign off is as sole beneficiary.
Yeah.
Then the plaintiff can't benefit in any way. And so it really kills their action because they're seeking to be plaintiff beneficiary. This is where you
Right.
get the co
And
relation.
when they're plaintiff beneficiary, they're treating us as the trustee. So they keep switching the roles.
The trick is to get us to be a default trustee. That's their default settings. And when we fight the debt or we don't acknowledge the debt, then we deem to be a delinquent trustee. And this is where they push us aside and act as co-trustee and start making decisions for the trust because they can see that we don't know which role we're playing because we're confused in the way we handle or respond to the court action, to the matter. So if you ever sign off, it should be as sole beneficiary to eliminate any other beneficiaries because they come in as in a co-relationship, right? Co-trustees, co-beneficiaries, co,
Codependent.
and codependent and guardian, co-parent. So they talk about themselves. They say the parent has a responsibility and you think, oh, that's me. Am I the parent?
It's
You
like a
think, you
toxic
assume you're the parent.
narcissistic relationship with a parent government.
Yeah, you have a toxic co-parenting relationship with your government who is trying to act as a decent tort trustee or guardian in a trustee where they have no appointed authority because the trust board has not granted them trustee or any kind of rights, powers, or privileges to do the thing that they're trying to do.
Let that sink in. So, all right,
Mm.
if that's
So,
the problem, how do we fix it?
well, we can create a trust, establish the trust, format it in writing, and declare the trust. It can be private. There's no need, there's no law in the world that states that that private trust has to be registered or statutory or regulated. We do have trusts that ideally are set up for holding property. And if you apply for an ABN for that trust in the public, right, make sure you have other non-profit trust boards or PMAs or foundations in the private that will control the fund managers or trustees and ultimately the trust. So you have a public trust in control of a private trust. And really, it's sort of like having your trust that's already public or incorporated from birth. One of the ways you can control that trust is by setting up a private trust for the purpose. So you establish a trust board to deal with any other trusts. And then from there on, you can have 100 trusts, like holding trusts, for each vehicle, for each registered piece of property. You have a separate individual trust. That can have an ABN and it's designed to operate in the public. But those trusts will ultimately be controlled by a board of trustees in the private.
See, this is the thing, as an accountant, for years and years, I've been setting up trusts, public trusts, ABNs, TFNs, corporate trustees, unit trusts, hybrid trusts. And it wasn't until moving to the private space and with the PMAs and the social compacts and then the trust board, realizing that there's about 1,000 other types of trusts. And in the public, there's like three or four, but then in the private, there's so many other trust relationships that you can create and express to govern yourself. And this is, again, where I just see there's so much limitation in what we're taught or how we're taught it. So, for someone who might have, you're aware of your straw man, your Sedeke trust, and you've got all these public trusts going on with business operations, and you think you've got your assets protected, but these trusts, they're regulated, right? They're regulated by the Commonwealth of Australia, the state, the federal legislation. So when we move to a private trust, what's the regulation there? Like what governs those trusts?
Well, the international rules of equity, and almost every country now accepts trusts and operates trusts. There'll be a few states or countries that don't. So they've been asked to embrace trust law in its basic public development or application amongst other countries. And so a lot of countries are asked to sign on to the international Hague regulations for trusts. And so most countries have, all the English countries have naturally, because England was a great starter or believer or user of trusts for a long time. So Australia, New Zealand, Canada, America, they'll typically always understand equity quite well. But for other third world countries that aren't so common, their trust law is not so common, you can sign on to the Hague regulations. And if anybody was to Google the Hague regulations, you'll see that the settlor has the choice of law in the jurisdiction of the trust, and they can choose whether it's just going to be where registered property is located. So if you have a registered holding trust with registered property registered in that state, then it'll naturally fall to the jurisdiction of that state. But typically, equity is quite well balanced and simple in its approach. But if two states conflict in their understanding of the trust, or that they're just conflicting states, then they'll always rely on the deed as the law. So it's very important when you're considering establishing or building a trust to set your jurisdiction and get the settler to understand what the jurisdiction
Because
is.
I know this is one thing that I've noticed over the last, 5 years dealing with the private is people coming to me saying, "Hey, I've got a private trust. I've got a private trust." And I'll say, "Cool, send me the deed." And I'll have a look at it. And inside the deed, the governance is set to Queensland or New South Wales or Western
Mm.
Australia. So these people who have these trusts, private trusts, where there's no ABN and there's no TFN, but the government is still state legislation, what happens then?
Well, it'll default to the government of where the trust is located. So they'll insist that your trust is under the state jurisdiction, the public trustee and guardian, or the state or the courts in the local state. But typically, what that is a state. It's a state of Queensland, a state of New South Wales. So when we form a private membership association, it becomes its own state. So this is why it's important to have a trust board within your state, or have a contract association operating as a state for the sole purpose to establish a trust board to manage property and other trusts. This is where your Sedeke trust will start to come in under control of the board of trustees, right, with their governing rule being the private membership association, its own independent state.
Right. We
And
create the
it,
PMA, we create our own state, and then establish a trust board so that we can protect our property.
yes,
Yeah.
correct.
Yeah.
Yeah, we have layers. It's like a layer cake, the deeper you go. So you can start in the public with your Sedeke Trust,
Mhm.
and then there's a board of trustees, another community trust, and the board of trustees manage the Sedeke Trust, which in turn, the community trust is managed by a private membership association, right? And so that is all set up under international law and the laws of equity.
Wow. Sounds very
Yeah.
complex. It's complex, but I don't know, like explain when we brought the trust board into the PMA, I knew even when we were writing that in 2 years ago that it was there for a really important reason. And I think it's only been for us in the last 6 months and the research and the deep dives and the uncoverings that we've realized just how important this trust relationship is. So the
Mm.
social compact in the PMA that creates the state is one element, but then having that trust association, I feel like it's kind of the keys to the the gateway of freedom.
Well, early on when we were establishing the PMAs, the trust board was an important component. And in our articles and our powers of the trust board, we've always stipulated that the trust board or fund managers or trustees on that board can control other property in trust, held in trust. Any property vested in to the trust board or trustee of the board and power of attorney granted to the trustee of that board has the full power, rights, and privileges to settle accounts, mortgage, convey, sell property, and manage your Sedeke trust,
which is
right? Because
property.
it's another trust. It's it's a trust. So it's always been there the board of trustees has always had the power or the capacity to control the Sedeke trust. It's just there's a lot of interest in how that actually works, the mechanics, and so we've got our training manuals for it.
Yeah, which we've been very busy on. Starting to finally come out with it. It's exciting to share, and it's the evolution, and it's a hot topic, and we've got people asking us all the time about different trust relationships and roles and responsibilities. And I think it's when you can understand the role that you play and where you want to sit, right? Because in the public space, we're kind of forced into this with this trustee relationship and then told to do things. When you look on the government websites and you see that all of the organizations, the government organizations, are for community service to the community for the benefit of the members. So even there is a trust relationship, at the highest
Mm.
level. So with a lot of people wanting to just go, you know what, fuck that, I'm out. How can we do it in a way that we don't jeopardize ourselves, we protect ourselves, but we also, I think one of the other things coming through, Jace, is that the not being combative, not creating problems, creating controversy, creating issues out in the community. Like, you kind of expected to operate at that
Yeah.
more mature level.
A level of maturity would be to respond to the government department if they're compelling or coercing you or threatening you through demands of menace, that you respond or correspond back to them. One correspondence that you could, one way to respond would be just to write a cover letter stating that it's a breach of the law to compel a beneficiary to act as a trustee regarding the financial affairs of the trust,
Wow.
right? For example, right? And you can say, this is how you can deal with them. You can just say, look, your demands and threatening demands, I can't respond to them because as a beneficiary, I don't handle or engage with the financial affairs of the trust. It's quite simple.
It
Mm.
is quite simple. So what's been one of the most I don't know, one of the most shocking revelations for yourself when it comes to trust law in the last 12 months?
One of the biggest secrets out there is that it's written into trust law is written in to the tax code and the tax charters or the taxation act in most of the Commonwealth countries. And they have a provision there that a creditor, which is code for trustee, can forgive the debt or offer consideration to forgive the debt for one of the beneficiaries. And these debt obligations, they're veiled. Under trust law, you can see the relationship. So when you're reading legislation, especially tax law, always look at it as a trust and how to operate as a trust. When you see these directors and fund managers and client services or corporate services, just deem them all as trustees, because if they're trying to tell you or insist that you do something, they're also trying to insist that you're the co-trustee. If they're a trustee telling you to do the same, pay it, then they've got a co-relationship with you, right? And this is one of the things people need to see. If you can start to see the relationship of trust, or the trust relationships being formed, you're going to do well, because then you can respond adequately. You can simply write back and say, "Oh, I don't see a trust relationship here. Is there a trust? Are you referring to a trust? If you are referring to a trust, I need to know the terms of the trust, and if you could provide the deed so I can understand the relationship better,
Yeah.
and so I can respond adequately." Now they have to, if there is a trust, they have to disclose it, otherwise it's fraud.
So, and I think this is one of the biggest things that I've even gone through, in dealing with this has been not going into the matter, right? When you receive
Mm,
the information, the demand, the letter, the request, the audit, the penalty, the fine, the whatever it is, it's you kind of have to stay at a higher level and perceive it at as you're not in it, because the minute you go into the detail and into the matter and all the reasons why this and why that and this happened and they did that and I did this, and like that's when you're then playing the game. And when you're
yeah.
playing in the realms of what's happening in the game, you're not out of the game. So under trust law or equity law, it's like we're the adjudicator of the game, or we're the gatekeeper before you
Mm,
even get into the game. We're standing at the gate and they're approaching and asking for something or offering something or demanding something or requesting, and
mm,
this is at the gate. We just, excuse me, what is this relationship? Can you define that before I let you in, and we even start talking about what's happening here? And I think that's
mm.
probably the biggest thing, because naturally humans want to go in and start arguing and carrying on and this and that, but you got to kind of stay above it. And
Yeah.
the amount of fear too, the amount of fear that is fabricated around those goings on, like those rules of the game and how you play it. That's what keeps people in the game. And
Yeah.
you got to like rise above it and look at it from a whole new perspective, and that takes time.
All that controversy and beating up a huge debt, which the tax officers usually do, this is to get you to defend and fight the debt, and defer to a trustee. If you start to argue the debt and don't acknowledge the debt, you become a delinquent trustee as a co-trustee. And so, by not acknowledging the debt, you're obviously not administrating the trust properly. So they try to step in and push you out as co-trustee, and then go, right, this is what we're going to do. We're going to settle. This is the amount the trust has got to pay. And if you're that's right, if you're arguing the wrong subject matter and not staying in equity but staying in basic commerce, you're you're basically going to fail, because they're running equity but pushing commerce in front of you. Your main goal your main goal should be to stay in trust law, keep it in equity, and when they drag you into commerce and the price for their own profit and gain, don't let them kick you out as a delinquent trustee, right?
So it's your responsibility to manage your affairs and keep it in order.
Yeah, that's right. If you have a written trust, you can refer to the deed. And this is a problem. People don't have written deeds.
So I guess just to wrap it up, we don't want to go too deep. We're writing up some books and doing some education on it. It is a complex topic, and it's really you want to make sure that the information is landing. So yeah, we're going to be releasing some more stuff, some more education. So if you want to know more, you can head over to our Facebook group, Untethered, or drop me a Facebook message, or I'm on Instagram and back on TikTok today. The other day, jumped back on there. So you know where to find me. Thanks for jumping on today, Jace. Appreciate it.